Assalamualaikum warahmatullahi wabarakatuh. I back to my beloved lecturer, Miss Siti Hajar. And in this video, me, Nurwarda, and my partner, Fatim Fahana, will be present about Bithaman Ajil and its practice in Islamic banking. So the introduction of Bithaman Ajil. Bithaman Ajil home financing is becoming one of the most popular forms of financing available from both Islamic and conventional banks in Malaysia. It was initially established as an alternative to traditional loans with the primary goal of ensuring that the transaction adheres to Islamic teachings, namely avoiding the practice of ushuri, or we call it as riba, which is expressly banned by Sharia. However, there are Sharia legal difficulties with BBA home financing in Malaysia. It is stated, for example, that BBA practice in Malaysia is not a true BBA based on Sharia BBA principles, but rather a form of Islamic banking transaction of buy-in. We call it as sell and buyback in nature, which is not accepted as a legal Islamic contract. Furthermore, instances involving BBA have been handled by judges who are unfamiliar with Islamic banking concept. As a result, the comparison with typical loan agreements appear to have impacted these civil court judges. Among their claims was that the parties to the BBA contract never meant to transfer ownership of the land. As such, it might be argued that it violates the primary thrust of a sale contract in Islam, namely the transfer of ownership, open delivery of the subject item. So next we go to the objective of this study. So the general goal of this study is to investigate and evaluate the use and practice of BBA home financing by Malaysian Islamic banks. The study's particular goals are as follows. The first one is to comprehend the notion of Bithaman Ajil as it pertains to house financing and its application in Malaysia. The second one is to assess if Bithaman Ajil home financing as practiced in Malaysia conforms to the true idea of BBA under Islamic law. The third one is to ascertain whether the Malaysian government has made any action to aid Bithaman Ajil Islamic banking. Next is to discover any additional option for home financing that are Sharia compliant. And the last one is to investigate and confirm whether Bithaman Ajil home financing in Malaysia is a genuine sale or loan.
Assalamualaikum warahmatullahi wabarakatuh. My name is Fatim Farhana binti Khairul Hazaki. So I will continue our presentation with the application of Bithaman Ajil in terms of Malaysia's evolution of Islamic banking cases. So Malaysia is one of the countries where cases involving Islamic banking have been reported in a number of legal journals. The majority of the cases involving Bithaman Ajil facilities involve Islamic banking from 1987 to 2008, which deal with ijarah financing facility. There are three main phases of the Islamic banking proceedings in Malaysia allow for an examination of the Malaysian court's perspective on the Bithaman Ajil facility. First phase was in 1994 to 2002. Bank Islam Malaysia Berhad v. Adnan Omar was in 1994, while Datuk Nik Mahmud bin Daud v. Bank Islam Malaysia Berhad was in 1996. In the case of Bank Islam Malaysia Berhad v. Adnan Omar, the High Court determined that the defendant was obligated to pay the full amount of the purchase price because he knowingly engaged into the contract after being made aware of its provisions. In this regard, the court used the traditional common law strategy according to which the parties are obligated by the terms of the contract. The question of whether the Bithaman Ajil facility contains a component that is against Sharia law as specified by the Islamic Banking Act and the Banking and Financial Institutions Act was not pursued further by the court. So the second phase was in 2003 to 2007. Bank Kerjasama Rakyat Malaysia Berhad BMC Corporation Sendirian Berhad was in 2003. Bank Islam Malaysia Berhad v Pasaraya Peladang Sendirian Berhad was in 2004. Arab Malaysian Merchant Bank Berhad v. Silver Concepts Nurian Berhad was in 2005, Malayan Banking Berhad v. Marilyn Ho Siok Ling was in 2006, and Afrin Bank Berhad v. Zulkifli Abdullah was in 2006, and Malayan Banking Berhad v. Yaqub bin Oj and Anor was in 2007. So in the second phase, the court expresses a desire to critically assess the guiding principles and financing options provided by the IFIS Islamic financial institutions. Particularly, in the case of Afrin Bank Berhad v. Zulkifli Abdullah, the decisions regarding the use of the Baik Bithaman Ajil facility is being hotly debated. The judge in this case favored a different strategy for resolving concerns in the Baik Bithaman Ajil facility than in the cases of Bank Islam Malaysia Berhad v. Adnan Omar and Datuk Nik Mahmud bin Daud v. Bank Islam Malaysia Berhad. It made a decision regarding how to determine how much must be paid in the case of a foreclosure. In his 30-page judgment, the learned judge in the case of Malayan Banking Berhad v. Yaqub bin Oj and Anor provides a thorough study of the use of the Baik Bithaman Ajil facility by examining the facility's overall aspect from both a legal and a Sharia standpoint. So the third phase, starting in 2008, the High Court's most recent decision, dated 8 July 2008, marks the start of the court's proactive approach to assessing the legitimacy and settling the concerns raised by cases involving Islamic banking. The plaintiffs in the case, Bank Islam Malaysia Berhad and Arab Malaysian Finance Berhad, were involved in 12 different civil lawsuits. All 12 civil lawsuits included BBA facility-related issues, and in the event of default, the defendants were required to pay the full selling price. The court's ruling can be summed up in the following manner. First, the Federal Constitution, the IBA and the BAFIA do not specify which madhab is to rule in the interpretation. Any component that is not sanctioned by the Islam, as understood by one of the recognized madhab, is not permitted in Baik Bithaman Ajil facilities. Second, the court acknowledges that the Baik Bithaman Ajil facility is a bona fide sale transaction. The interpretation of selling price in the case of Afrin Bank Berhad v. Zulkifli Abdullah was cited, in which the court rejected the plaintiff's interpretation and used the equitable interpretation. So next, we move to the Baik Bithaman Ajil facility legal documentation in Malaysia. So the first agreement is sale and purchase agreement. It is one of the most crucial agreements when securing such a facility from banks. So let's say, for example, Encik Ahmad wants to purchase a home from a seller. The sale and purchase agreement will be completed between the two parties. Encik Ahmad would be responsible for 10% of the property's cost. So this agreement must be signed by the customer, and the bank must receive it before the financing application can be processed. So according to 1996, Encik Ahmad, which is the client, the seller and the bank as the financier would sign to a novation agreement. However, this practice was later discontinued. This is because it has been stated that the developer or seller's refusal to sign the agreement was due to the desire to avoid any potential rights or responsibilities associated with it. Furthermore, the developer or seller is not interested in where or how the client gets the money to buy the house. Additionally, it was claimed that this innovation agreement was also unimportant because the client had already obtained beneficial ownership of the house by paying 10% of the purchase price. So the second agreement is property purchase agreement. This is a deal that the client and the bank made. It should be mentioned that the purchase price typically consists of the remaining balance of the home's price, as well as certain additional expenses like legal fees. This will undoubtedly raise the borrowing amount above the home's residual value. However, the client and the bank can negotiate the financing amount bank is able or willing to fund. In doing so, the bank's policies, the client's credit worthiness, and other variables will be used to determine the final financing amount to be given to the client. So the third agreement, which is property sale agreement. So once more, this contract is executed by the client and the bank to enable the bank to return the asset to the client. The property sale agreement must be signed following the property purchase agreement. Based on the agreement established between the bank and the client, the specifics of how the payment of the price to be made will be described.
Next, we go to the finding and discussion in the study. So, in addition, there are some outstanding issues in BBA financing that want attention. So, these are some of these concerns discussed about the problems in BBA financing. The first one is right to recall the facility clause. According to the traditional loans agreements legal documents, the bank has the authority to cancel the facility, seize the property, and recall the facility. This is not the case with BBA financing. This is because the house ownership has now passed to the customer as a result of the PSA. Therefore, the bank has absolutely no authority to reclaim the property. The purchase price of the property is what the bank is legally entitled to. The traditional right to recall provision is therefore inappropriate for the BBA capability. With a certain modification, this condition can be added in the BBA financing facility. The ability to recall the BBA financing facility gives the bank full authority to revoke the agreement and make a claim for the outstanding balance, but not the authority to seize the collateral. If a property is pledged as security, the bank may sell it, make a claim on the outstanding sum, and return the remaining funds to the customer. It's collateral from a third party. A person who wants a facility may occasionally be required to give the bank additional collateral. In place of the sought facility, the individual who owns other property may establish a legal charge on that property in favor of the bank. A person may establish a legal charge over another person's property if they have no other assets. However, a letter of gift must be performed before this charge may be issued, in which case the third party will sign the letter on the applicant's behalf. The customer will then charge the property in the bank's favor. Next is possibility to transfer the receivable to a third party. The client must pay the selling price to the bank when the BBA contract has been properly executed. Unquestionably, the bank alone has the right to accept the money. As a result, the bank has the authority to sell the receivable that it will buy from the client without the customer's consent, because the bank has exclusive ownership of the receivable. Typically, a third party will buy this receivable from you and then issue a bond to pay for the purchase. Mudharabah Chagamas bond is an illustration of such a bond. Chagamas Berhad was the issuer of this bond. In accordance with this arrangement, BIMB, Bank Islam Berhad, sells to Chagamas Berhad its Islamic home financing facilities PBA receivable based on the idea of the sale of debt at a discount. Following this transaction, Chagamas Berhad received all of PIMB's right in relation to the loan. It indicates that Chagamas will now have the legal authority to collect debt from the BBA installment. As a result, the institution will send off all the installment from the consumers under the BBA to Chagamas on a monthly basis. In contrast, Chagamas will issue Mudharabah bonds to raise the money required to finance acquisition of this receivable. As a result, those who own the bonds become shareholder in the company of which Chagamas is the founder. They will profit from the portfolio of house financing cash flow stream. Number 5 is BBA financing or selling of the non-existing. As previously explained by me, the Malaysian BBA financing instrument is used for both completed and under construction properties. Although there is no concern with the latter practice, there may be one of the former. This is so that the property that is transacted in BBA financing for a house under development does not yet exist. The decision on the presence of subject matter in a sale contract may be in conflict with this. The BBA facility on property still being built is not permitted. According to the majority view of judges, even if the position of Ibn Taymiyah and Ibn al-Qayyim, which permits the sale of non-existing subject matter, is adhered to, there is still one major problem. The opinion is predicated on the near certainty of delivery. They contend that the contract is nevertheless legitimate even though the subject matter did not exist at the time of conclusion, as long as both parties are certain that delivery will be achievable at the predetermined future date. It has been advised that banks utilize other forms of financing for real estate that is still under development to prevent any potential competing difficulties. For instance, when financing an asset with a future delivery date, banks may employ a parallel istisna contract. In istisna contract, the maker or the developer will make the object of istisna or musta'na available at a later time. As a result, it is the most precise contract that can be used as a financing tool for property that is being built or that has not yet been built.
So for the conclusion, to sum up, Baik Bithaman and Ajil contracts are less common in finance products now because of the Sharia concerns they raise. Most Islamic banks and financial organizations now substitute tawarruk contracts for Baik Bithaman and Ajil contracts. As a result, it must contain all the necessary components of a sale contract, such as the essential parts arkan, the conditions shurut, and the deal's legal implications. So our presentation has covered the some outstanding issues in Baik Bithaman and Ajil financing, practical application of Baik Bithaman and Ajil finance in Malaysia, including Malaysia's evolution of Islamic banking cases, and BBA facility legal documentation in Malaysia in great detail. So I guess that's all from us. Thank you for lending us your ears, and thank you to our beloved lecturer, Ustazah Siti Haja, for teaching us.